Hello and welcome to our webinar on coronavirus and the legal questions evolving around it. Today, we will give a short overview on the most important questions that have come up lately. Anna Förster will guide you through employment-related questions and will give an overview on short-time work and occupational safety requirements, and Benedikt Rohrßen will speak about the impact corona may have on contracts. Senninger will update you on restructuring issues, and Bert Kimpel will speak about tax matters. I, Voigt, will give you an overview on privacy-related questions. We'll start right away with the overview on employment law. Anna, the floor is yours.
Thank you, Paul. So we start with having a look at the employment-related aspects of the coronavirus crisis. The consequences of the spread of the coronavirus have reached the German labor market. Companies were forced to react, and I just want to give you a high-level overview on certain topics regarding occupational health and safety compliance, work from home, and short-time work. We start having a look on short-time work as a tool to soften the effect of the current crisis. This has been proved quite successful during the last financial crisis in 2008. And so the German legislator has again opted for this version and has passed a law, the so-called Work of Tomorrow Act, to improve the regulations for short-time working compensation, to make it easier to apply and receive this compensation. And the main changes in the law are that only 10%, before it was 30%, 1/3 of the employees in the company must be affected by the loss of working hours. The social security contributions, the employer's social security contribution, will be fully refunded by the Federal Employment Agency, and this was not possible before, so it's for the branch of the temporary agency very important that their workers are also able to receive the short-time work compensation. The introduction of short-time work has two sides. We have, on the one hand, the employment part, and on the other hand, the social security part. To introduce short-time work, a legal basis is required. So there's the need for either an individual agreement between employer and employee, a collective bargaining agreement, or if there's a works council, a works agreement must be concluded. And one of the most important points with regard to short-time work is that the works agreement, or if there is no works council, the individual agreement, has to stipulate certain points. We have case law from the last financial crisis which states very strict criteria in order that there is a valid legal basis. So it is really of utmost importance that those agreements are very carefully drafted. The works agreement must stipulate, this is a minimum requirement, the start and duration of short-time work, the location and distribution of working hours, as well as the names of the affected employees. If one or all of these points are missing, the works agreement will be invalid, and it would have very severe consequences in such form that once all the crisis is over, the agency will review whether all criteria have been met, and if not, they will claim back all the paid compensation. So I can just stress this point to be very careful when drafting the works agreement or the individual agreement. So if we have this employment legal basis, we must look whether all the social security criteria have been met as well. We have, of course, there must be some loss of work, obviously, either based on economic reasons or, as we have at the moment, an unavoidable event. Either the whole company must be affected by this, or it is sufficient if only certain company departments are affected. Furthermore, the employees who are affected must still be in an existing employment relationship. So it shouldn't be terminated, and the loss of work has to be reported to the Federal Employment Agency. I do not want to go into all the details you see right now, because this shall just be a high-level overview. But again, there is, from my point of view, very important that employers make sure one point, that the short-time work is unavoidable. And short-time work is only unavoidable if all other measures have been opted for. So this means the employer must grant all the outstanding vacation. We have seen leaflets and statements from the Federal Employment Agency stating that only the outstanding vacation from 2019 or previous years have to be granted. So this is better than during the last crisis, where all the vacation days had to be taken. And the other point is all of the working time credits have to be reduced to zero. There are certain exemptions from it, but as a basic principle, it has to be reduced to zero. But you need not to accumulate negative working time credits. Again, as with the drafting of the works agreement, individual agreement, please make sure that you stick to these points, because if not, the Federal Employment Agency may claim back the compensation paid. And we have seen that in the past, after the end of the financial crisis, 2008, the Federal Employment Agency did have a look at the books, at the files, and when not all requirements were met, they did claim back the money. Just a short look on the application process. It's a two-step process. So first, you have to notify the local district employment agency that all the requirements I have just spoken about are met. The employment agency will then approve this, but only by means of preliminary notice. So they can, after they have reviewed it, come back and say, oh, the requirements haven't been met, so please pay back the money. Then in the second step, the employer has to apply monthly for the payment, for the compensation. Again, there are some forms you can see at the homepage of the Federal Employment Agency. We have developed a legal tool to help employers with completing this form. So you see the link, and this is also available in an English version, and I think it helps to get you through all these forms. The maximum period for short-time work compensation is 12 months, and the amount of it will differ whether employees have a child or not, between 60 and 67% of the net pay difference. So this is what I wanted to say, like really short overview on short-time work. And I will come to the next point. We have now a look on the possibilities to work from home. This has become, of course, very urgent during the last couple of weeks, as more organizations were forced to shutter their operations. Of course, the first step is always to identify who can work remotely. Obviously, a waitress can't do that, but after having identified all employees who can work from home, from a practical viewpoint, companies need to look whether there are abilities to work from home in terms of have all employees computers, have they sufficient internet access, and so on. From a legal viewpoint, we need again a legal basis. This can be an individual agreement between employer and employee or works agreement. We do not have a statutory entitlement to work from home. This is different than, for example, in the Netherlands or in the US. When we talk about working from home, we have to distinguish between working from home in the sense of the German workplace regulation. This means where the employer provides the employee with a fixed workplace, because then you have to obey certain occupational health and safety standards. and mobile working, which is just when employer and employee agree that the employee may work from outside the company. If the latter is the case, then certain occupational health and safety standards must not be met, but be careful, because if you now send employees home to work remote without looking at all these occupational health and safety standards, this is not what the legislator intended to have permanently. So what happened in the last week is that people were sent home without an agreement. There hasn't taken place any risk assessment, and because obviously the employers had to react. But now, as the first dust has settled, it is important that when employees shall work for a longer period from home, that you should make sure that all the regulations are obeyed, in particular regarding occupational health and safety standards. Another question was always whether employer or employee can unilaterally decide to work from home. If we talk about remote working in the sense of the German Working Act regulation, workplace regulation, the answer is simple no. There is no unilaterally decide, the employer cannot unilaterally decide whether to work, that the employee works from home or not. Of course, in emergency cases, the employer may decide so, as he has a duty of care. The employee may not just decide to work from home, just she fears to become infected at the workplace. This, of course, may differ if a colleague has been tested positive. So there is no straight answer, and you have to look at each individual case. Just one last note, because it's an evergreen, working from home does not mean that the regulations of the Working Time Act do not have to be obeyed. Of course, it still applies. So as an employer, please make sure that you inform your employees that they have to obey the 11-hour resting period, as well as the working time, that this is not exceeded. The employer is responsible for compliance with these provisions, and violations will result in heavy fines. So just keep this in mind as well. So lastly, we have a look on what employers should consider to maintain a safe workplace and reassure their employees that management is appropriately monitoring and responding to this situation. There is a general duty clause of the Occupational Safety and Health Act that generally requires employers to provide employees with a safe and healthy workplace. So, of course, the employer is obliged, and I'm sure everybody has done that already, to introduce strict hygiene regulations, to inform its employees of specific corona-related risks and dangers, and, of course, instruct employees to report symptoms and positive test results. The employer must pay the cost of such measures, and if corona is detected or suspected in the workplace, of course, the employer must inform the workforce, identify possible contact persons immediately, and consult the local health authority. As said before, then you have the employer has to look whether working remotely can be arranged and make all the possible things that the employees can work from home. So the last point is always who is going to pay the remuneration. Of course, if the employee can work from home, the employer has to pay the normal wage, so there is no difference. If we talk about quarantine, it depends whether this is based on order of the authorities or not. in the first case, the employee may be entitled to a compensation based on the German Act on Protection Against Infections. So you may have a look on this regulation, which has been previously not known, so to say, but which is now quite an important regulation. So this was all I wanted to say in high-level overview on employment regulations, and I'm happy now to hand over to my colleague, Paul.
Thanks much, Anne. We'll speak now a bit about the privacy implications that come with Corona and data processing related to Corona infections. As Anna has mentioned, the employer usually has a duty of care towards its employees and needs to protect its employees from any kind of dangers. Thus, many employers want to collect some kind of information on whether some of its employees or visitors entering the premises have been or potentially may have been infected with the coronavirus. Some employers want to take symptoms of their employees, and we have even seen employers only allowing people onto the premises after having taken their temperature. Employers want to ask certain questions about whether employees have recently been in a risk area or whether they have been in contact with infected persons in order to take precautionary measures. If an employee or a visitor who has visited the premises of the employer has been tested positively for coronavirus, many employers also, of course, want to share the name of the infected person within the company to inform and warn other employees. All of these data collection scenarios and data uses will obviously trigger a certain privacy concerns. So what are you allowed to collect? Which kind of data are you allowed to collect? And how are you allowed to use respective data when it comes to corona infections? As you may know, the GDPR, General Data Protection Regulation, has strongly harmonized European privacy laws, and very generally speaking, the same privacy laws apply across the European Union. Still, this is different to some extent when it comes to health data. Health data is considered sensitive data by the GDPR, and such sensitive data is regulated to a stronger extent by national privacy and employment laws of the various EU member states. So you can say the extent to which health data can be collected and used differs from country to country, and it is difficult to give a unified approach with respect to all of the EU. Some countries are more lenient and more business friendly in that regard. For example, UK, which is no surprise, they step back a bit when it comes to privacy concerns currently relating to COVID-19. Even though the UK is technically no longer part of the EU, it still applies GDPR to the same extent as the other countries. Other member states take a more restrictive approach, and the approach of the German regulators, I would say, is somewhere in between the restrictive and the lenient approach, and can therefore, at least to some extent, be used as some kind of a benchmark for what regulators in Europe generally recommend when it comes to collecting and sharing information on corona infections. In a nutshell, you could say data relating to corona infections should only be collected and used in an, of course, reasonable way, which is obvious, and the individuals need to be informed about the data collection and use upfront, also no different to any other kind of data processing. Data shall only be used and collected to the extent necessary in order to achieve the desired purpose. And this makes it a bit difficult to collect data on symptoms in the view of the regulator, as these symptoms will not give a very strong indication on whether a person is actually infected with coronavirus. The coronavirus symptoms are often a bit generic, such as fever or headache, and such a symptom may, of course, indicate a corona infection, but may also indicate a lot of other diseases and not necessarily corona. Also, even not having any kind of symptoms does not necessarily mean that the person is not infected, as the symptoms of coronavirus may show only at a relatively late stage. So collecting information on symptoms is regarded as as problematic from a privacy perspective. On the other hand, collecting information on whether an employee or a visitor has recently been in a risk area or has been in contact with an infected person is generally not considered sensitive data and can more easily be collected and used. When it comes to sharing the name of an infected person within the company, the authorities tend to take a relatively strict approach. Data sharing on a name basis is generally not permitted, and other less intrusive measures shall be taken, such as, for example, communicating the infection only on a no-name basis, like someone in the third floor has been infected or someone from the HR department, if that is possible. If it is not at all possible to only communicate on a no-name basis in order to protect the other employees, in exceptional cases, but again, really exceptional cases, this shall not become the rule, the name can also be shared as well within the company. As I mentioned, the opinions of the various regulators in the various EU member states differ to some extent. This is why we have prepared an overview, a very high-level overview of the opinions of the various regulators, which we also regularly update. It is, you can find it on our website, and the link is provided here on this slide in our presentation. Still, collecting and using information on corona infections is not the only issue that may trigger privacy concerns. Quite a few of us are obviously working from home right now, and so is Boris Johnson, the Prime Minister of the UK. And just yesterday, Boris Johnson very proudly shared the screenshot of a web conference meeting that he had with the members of his cabinet to show that he and his cabinet is working from home. But if you take a closer look at the screenshot does not only reveal that they're using Zoom, which is currently in the press for allegedly not complying with GDPR requirements and sharing data with Facebook, but apart from that, the screenshot quite prominently shows the Zoom meeting number, and if the same meeting room is used again, potentially third parties might use this number to dial into the conference that the cabinet meeting will be taking place in. And the screenshot also shows the contact details of all of the members of his cabinet, which is of course not recommendable neither. A screenshot like the one that Boris Johnson twittered is one reason why many companies have implemented working from home policies, even though these policies are not strictly required by law. Still, having such a policy may mitigate the increased risks that derive from working from home. For instance, the employer will have less control over the business devices and the documents of the employee when the employee works from home. Obviously, there is less control than if the employee would work from within the office. Potentially, other people living in the same household as the employee might have access to the business devices and documents, and the employer can also not fully control the IT security measures at the home of the employee. For example, the Wi-Fi used by the employee might not have a strong encryption, not as strong as the one that is used in the office. In order to mitigate these risks, at least to some extent, the employer can provide, for example, business devices that are strongly encrypted already and should also encrypt data communication, data in transit, which basically means that when the employee communicates with the network of the employer, a VPN tool should be used. Also, the employer might encourage the employees to work paperless so that no documents lie around in the household of the employee, which then other people living in the same household could access. If documents are used by the paper documents are used by the employee, the documents should be shredded once a day or once they are no longer used, at least. So the employee takes care that no one can access these documents. The employee should also take care of securing his working environment and not letting other people have access to his business device and documents. Still, if your employees use business devices when working from home, you're already relatively well prepared from a privacy and IT security perspective. If your employees use their personal devices, on the other hand, when working from home, things become a bit more difficult. Employers can't control, obviously, the security measures taken on personal devices. Potentially, the employee does not regularly update his operating system or does not have an up-to-date antivirus scanner on a system. If personal devices are used, personal and business data will be intermingled on the employee's device, which obviously leads to the fact that it will be difficult for the employer to gain control over the business-related content. One measure to mitigate this concern would be to have the employee work in a virtual environment, which basically means that even though the employee uses the personal device, the data processing would take place basically in the cloud on the systems of the employer. So privacy concerns would be mitigated. If such virtual environments do not exist in the company, which still is often the case, in particular in smaller companies, the employees should at least regularly back up their business data to the systems of the employer and regularly delete business data from their personal device to allow a certain kind of control over the business content for the employer. And it probably will also make sense that the employer gives at least some kind of guidance to the employees on required security measures, and not only guidance but also assistance, because just paper tigers that don't actually lead to an implementation of security measures won't help anyone. Some guidance about what data may actually be copied to the personal device will certainly also be helpful. We have summarized some of the most important questions relating to working from home in an FAQ document, which is also linked in this presentation on this slide. Thanks much. That's it on privacy. If you have any questions, please feel free to reach out to us, of course, also after the webinar. And Ben Rohrßen will now speak about the impact that Corona may have on contract law. Ben, over to you.
Thank you, Paul. And yes, I'm going to talk about how to ensure your business continuity with regard to your commercial contracts. So you see already here this checklist, but the bad news first. German law does not really provide the easy way out if you're under distress right now because of the coronavirus in your supply chain. So the easy way out, what would that be? That would be, of course, something like displayed on the news recently, which was that the government, just as a joke, announced to reset the clock back to 2019 and cancel 2020 and start over again. But unfortunately, that's not going to happen. Instead, what you have to do if you want to take care of your supply chain is you have to go the meticulous way and check your contracts and communicate. So that's the checklist I provided, and we're going to go through it. First of all, most important is you start to analyze your supply chain, and you start to take a look into both directions. First of all, at the supply side, and then at the customer side. As regards to suppliers, you check whether you have an uninterrupted supply or whether there's a shortage or some bottlenecks in your supplies, especially as regards the essential raw materials you need for your products. Then you can mirror that with the customer side, and there where you have a shortage on the supply side or delays expected in delivery, you can check which of your products are affected and which of your customers will be affected from that. And then you can start prioritizing between the customers and the products in order to afterwards, step 4 in this checklist, afterwards you go into the communication. But before you go into communication, there's other things to do. First of all, number 2, check your contracts. And again, as regards to checking your contracts, you check both perspectives. You have to see whether you're a supplier. Then you ask yourself the question, what's my obligation? What do I have to do, regardless of this crisis, regardless perhaps of delivery problems with my raw materials, with my products, with my sub-suppliers? And as a customer, you ask the opposite question, what's my right? What can I claim from the other party, my business partner? And then there's generally 2 issues from German law perspective, which you have to think about. First one is, am I obliged to supply or have I a right to be supplied? And the second one is about damages. May I claim damages if I do not get supplied on time? So the first one, and that's why I said the bad news is German law does not really provide the one-size-fits-all answer. Am I obliged to supply from a supply perspective? The answer is generally yes. Why is that so? That's so because the supplier generally remains obliged to supply. Once you have concluded a contract as a supplier, you bear the procurement risk, and you have to take care, especially with generic goods, that you're able to produce your products and supply them to your customers. So that goes for every product where you have more than one sub-supplier. However, of course, there are exceptions. It depends, first of all, on the contract you have concluded, on your terms and conditions. So if you're lucky, you have some force majeure clauses in there or some hardship clauses which you can rely on, which you can at least invoke. But if you do not have them, then you can perhaps say that it's impossible for you to supply. And that, however, under German law happens only in very rare cases. One case may be where you're the only supplier of this product, which may happen, for example, in the automotive industry, where you have a very highly technological product, very individualized, and there's nobody else in the world who can, at least right now at the moment, manufacture the same product. The same may occur right now with breathing masks, where at least temporarily there may be an impossibility to supply them. And it's, as a general rule, as I said, German law does not really give you the easy way out. The general rule is it depends on the contract, but generally you have to continue to supply, and even if that needs to go back to your warehouse and take out all of the products you have on stock, or if you need to ask third parties to sub-supply you. So that was the one point, obligation to supply. On the other hand, there's still the second issue, damages. Do I have to pay damages as a supplier, or as a customer, am I entitled to claim damages for late supply or for lack of supply? And here again, the general answer is yes, you are obliged to pay damages if you breach your contract. And the contract, here again, the answer is parallel and mirrored. If you're obliged to supply and you do not supply on time, then generally you have to pay. However, it's not only the contractual side which you have to take care of, it's also a third point that you have to check for additional obligations. Perhaps, especially if you do not have a force majeure clause you can rely on, you can invoke, then you still have to look if there's something else. In German law, for example, poses additional obligations and additional duties in long-term business relationships. So, classical example is that of distribution or franchising, where you are a franchisor and you have your franchisees all around in Germany, and you have a lack of your product. Perhaps you have been sub-supplied only with 80% of the products instead of 100. So you cannot just arbitrarily choose to give all the 80 to your franchisee in Berlin because that's the one you like so much, or to the one in Munich. But you have to divide, and you have to take care of doing a just and equal decision because you have a special fiduciary duty of this long-term relationship. So you have to check that you distribute either equally or at least proportionally. Then, once you have checked both the factual side, so number one, the supply chain, how are things going? Second and third, the legal aspects, how are the contracts? How is the statutory law? Is it helping me or not? So you arrive at the fourth point and you see what your strength is and where your weaknesses may be, and then you can start to communicate. And you should, as soon as possible, also communicate, again, to both directions, to the suppliers and to the customers. Make them understand the situation. Do it as soon as possible because you might want to minimize potential damages, and make customers and suppliers alert so that they can be prepared of the situation. What is there to do? So what I've brought you here is 5 examples how you can communicate in this crisis, 5 best practice examples which show you how to perhaps even make a win out of this crisis, out of this situation. So first of all, as I said, you have to look to your suppliers. And that's an example out of the automotive industry, which I've recently taken care of. So there was once one customer who had difficulties because the factory was closed down due to the authorities. So this customer could not take any goods in. So what the customer did was he wrote letters, standard letters to all suppliers, and then called afterwards. So important thing is to make everybody alert of the situation. Tell them we're not able right now to accept your goods. We have to take care of something else. We have to discuss what to do if you can still keep them in your warehouse. but communicate as soon as possible in order to avoid that the trucks arrive at your warehouse, at your factory, and cannot enter, and then there's additional costs involved. But it's not only the supply side, it's also the customer side, which you have to take care of course. Again, looking into the other side of the supply chain. And here is a good example of what you can do to inform the customers about the brick and mortar store situation, so that the brick stores are likely in these days, at least in Germany, closed, most of them, if it's not food retail especially. But what you can do is, at the same time, you can redirect the customers to your online stores. As regards online stores, another very, very good best practice example is what you can do is you update your customers about the current situation. You perhaps tell them you are proactive. You tell them about potential possible delays right now because delivery might get delayed in general. And what you can do is you also can do advertisement for yourself. You can grant free returns for the goods in order to enable customers to still buy more online. What you also can do is that you take the customers with you away from the tangible products going to digital products. So those products which are easily available and where there's no shortage generally. However, of course, as with sports, there may be right now a shortage. Bundesliga doesn't happen right now. So in that case, what is left at least is what you can do is customer retention management. So you can offer something else, and then you can communicate that this is not the end of the game. It's just a temporarily timeout. And then you can hopefully do a win-win out of the situation. Thank you. Alexander, it's up to you.
Thank you very much, Benedikt. And thanks for having me on this webinar. My name is Alexander Senninger. I'm a salary partner from the Taylor Wessing Hamburg office, working in the restructuring department. And today I want to give you some insights into the new legislation and measures you can take based on some FAQs we received so far. But first of all, I have to give you an explanation of the legal background under German insolvency law, because otherwise you won't be able to understand the changes recently made. So let's go into the basics of German insolvency law first, before we then come to the new legislation based on the COVID-19 pandemic. The most important duty for the management in crisis of a company is to assess whether to file for insolvency and at which time. This is laid down in section 15A of the German Insolvency Act. If illiquidity or over-indebtedness occur, then the managers have to file for insolvency. This must be done without undue delay, at the latest 3 weeks as of the insolvency maturity date. So this is the first very important information. Again, against many expectations, it's not that you always have 3 weeks. They are not optional, but only a maximum time frame. So it may be the case that you have to file earlier if possible and required. Now, the first and most important reason to file for insolvency is illiquidity, which is laid down in section 17 of the German Insolvency Act. Illiquidity is given if the company is not in a position to settle its due liabilities. According to the German Federal Court of Justice, that means that whereas as from now 19% coverage shall be sufficient, if the remaining up to 10% can be covered within the next 3 weeks, taking into account all further claims and liabilities. Apart from that, there's a rebuttable presumption, which is that a company is generally deemed to be illiquid if it has ceased payments. But this is only a presumption, and I hope that you are not in a position that you have to stop making payments, but can still make payments which are required to continue your business. Apart from illiquidity, there's the insolvency reason of over-indebtedness, according to section 19 of the German Insolvency Act. Over-indebtedness is given if the company's assets no longer cover the existing liabilities, unless according to the circumstances, the continuation of the company is predominantly probable, and the company is financed according to a plausible and realistic liquidity plan throughout the current and following fiscal year. So those are the two mandatory reasons to file for insolvency. There's also the optional reason of imminent illiquidity, but this is not the relevant point here. In parallel to this filing obligation, there's a high risk of liability for the management relating to payments leading to insolvency or made after maturity of insolvency. And there might also be criminal sanctions and risks to face criminal sanctions for a delay in filing for insolvency. So generally, apart from the duty to file for insolvency, managers have to take the reasonable standard of care of a prudent businessman. This takes us to the new legislation on the next slide. Against this background, let us now focus on the new law relating to the corona crisis. The new legislation provides for a suspension until end of September this year for filing for insolvency, which might even be prolonged by the German federal government until end of March 21. But this is only given under two conditions. So it's very important for you to know there's no automatic general suspension for insolvency filings, but the following two conditions have to be there. The first is insolvency must be caused by the effects of the COVID-19 pandemic. And secondly, there must be a prospect of recovery from an illiquidity. In this context, there is an important legal assumption in favor of companies in crisis, also implemented by the new law. If you, as company in crisis, was not illiquid at the end of last year, i.e. on 31st December 2019, and you can prove that based on financial statements or other reliable financial information, there is an assumption that the crisis has been caused by COVID-19 pandemic, and there are prospects of eliminating an existing illiquidity. However, this is only a presumption, and it's not 100% clear and still up to dispute whether this shall present a shift of burden of proof. So in any case, even though you have this presumption, you should be able to document that you have not been illiquid at the end of last year. By the way, if those two conditions under the new law are given, there's also a suspension of foreign filings, so to say, of creditor third-party filings of insolvency for companies for 3 months if insolvency maturity, i.e. illiquidity or over-indebtedness, was not given prior to March this year. The new law also focuses on the question of directors' liability, which is a consequence of the suspension under the two conditions, because there might be also a potential suspension of prohibition of payments for directors. Usually, liability for payments leading to insolvency are generally prohibited, but now there shall also be a suspension in order to enable the continuation of your business and keep the business alive in the ordinary course of business. So the managers should still be allowed to make payments to keep the business alive without facing any liability for payments that lead to insolvency. That leads us to the next slide. The third very important area of the new law, which is also a consequence of the suspension laid down above, is the question of payment behavior with regard to clawback claims, deferrals, installments, and the like. Usually when it comes to payments by contractual partners in crisis or deferral agreements and installment agreements, there are high risks of insolvency clawback claims in Germany. However, this shall not be This shall be considerably reduced and mitigated by the new law within contractual relations in particular. Thus, there shall be no clawback claims regarding concurrent coverage, i.e. For services within contractual relations, especially with regard to the services that have to be exchanged, as long as the two conditions I mentioned above are given and the new law is applicable. Of course, this regulation leaves much space for debate and legal uncertainty, so I'm not sure in which direction this will go. Nobody knows that so far, but my colleagues and I already spent some thoughts on how to gain more legal certainty here. And I think one good approach would be that companies receiving money from partners and which agree upon deferrals and installments with their contractual partners shall reach an agreement stating that if the party is or becomes unable to pay its due debts as a result of the COVID-19 pandemic, taking the status from now, and if there is no prospect that this restructuring and financing efforts will be successful, the partner shall give notice immediately so that you have more certainty if he doesn't give notice that the new law is applicable and that no clawback claims risks exist. Of course, this must be assessed on a case-by-case study on the individual cases and cannot be generally the utmost recommendation. But this may generate more trust and certainty and reliability if no correspondence or notice is given. Okay, that already leads us to the conclusion. I hope you got from the above that as managers of directors, you have to be active. You cannot simply rely on the new law because there are conditions to be fulfilled in order to take advantage of the new law. Besides, of course, you have to generate liquidity and communicate, as has already been mentioned, with your contractual partners and authorities. Assess your situation and document each measure that you undertake and date those documentation so that retrospectively you are able to present to any potential insolvency administrator or whomever that you have taken the necessary steps. You also have to consider your restructuring options and engage appropriate advisors where necessary. Of course, we at Taylor Wessing are very happy to support you there in order to maximize your chances to fall under the new suspension law, or even if you decide you don't want to go the way with those 8 packages and new suspension law, there might also be a better option for you when filing for insolvency to be restructured within insolvency proceedings, for example, by the process of self-administration and protective shield measures. Okay, thank you very much. That was the insolvency part on this new law. And of course, Tobias Rode and I, my colleague from Taylor Wessing, are happy to answer any questions afterwards. Thank you, and I hand over to you, Bert Kimpel, for tax.
Thank you very much, Alex. Well, yes, some additional comments from a tax perspective. Because as you all know, taxes are an issue as long as you make profits, but unfortunately, tax law is also an issue if you don't make profits and if you're in a restructuring situation or contemplating measures or whatever. So I would like to guide you through some basic scenarios and explain the basic tools from a tax perspective for you, so that you can already assume some implications you may want to consider further. And secondly, just a brief overview about what's in the discussion right now with respect to state aids. I just mentioned here on the slide 2 billion for startups, but we are also discussing about bigger packages, and it might be interesting to understand how it all works from a technical perspective, because if something goes wrong, or even if it does not go wrong, it might also have considerable tax consequences. So just to start here, maybe Yes. So just to start here, I mentioned scenario 1, that equity swap. Why? Well, a typical scenario looks as follows. You have a company which has considerable debt, and the profit situation is shrinking, and you may want to restructure your passive side. In these situations, it's always an option to swap from debt to equity, or to waive the shareholder loan, for example, or in more serious cases, also third parties agree to waive loans or to get reasons rights or whatever in return for that. Although you're already in a loss situation, you may trigger serious tax consequences you surely want to avoid in this situation. So just to give you some background, just imagine that you have a €100 liability on your passive side, and the lender would simply waive its claim. Then you would technically trigger a profit of 100, which would then in turn lead to taxes in the amount of roughly 30. And this is what I'm talking about right now. When you're in a loss situation or you want to restructure your company, you don't want to pay 30 to the tax authorities without liquidity flowing in from that. So this is the starting point, which has always been taken into account when you are in a restructuring situation and you realize, or together with your banks or financing partners or shareholders or whoever, that you should do something about your accounts. And there's a number of technical ways. We will just go through it in the next step. Just as a rule of thumb, what are the tax consequences in the basic scenario of a waiver, for example? Well, as to the extent the loan is not recoverable, then the tax authorities argue, well, this would then trigger a profit, as just mentioned, and to the extent it is recoverable, it would be tax neutral. It would be treated like a contribution for tax purposes. So if you, for example, have a liability of 100 and the company could repay 50, you would have a profit of 50 and a tax neutral contribution of 50. And in practice, a quite common situation is that you do not want to waive 100, but only 50, and then you are wondering, would this trigger a taxable profit of 50, 0, or 25? And we have some guidance from the jurisprudence, which basically says that in this situation, you should trigger a profit in the amount of 50, i.e. in the very first step, the non-recoverable part would be used for that. This is to some extent bad news, because it means that a taxable profit would arise, but it also gives rise to some structuring ideas, i.e. use of tax loss carry forwards, etc. So basically, and this is the bottom line, such scenarios do have serious tax implications, but give also rise to some tax planning and structuring considerations. And as I just mentioned at the beginning, not making profits does unfortunately not mean that taxes are no longer an issue here. So this is what I just pointed out with scenario 1, that equity swap or a waiver of a loan or whatever. This is a typical scenario. We all hope that none of us, especially none of you, would get into this situation, but it is a common situation, and I just wanted to mention that there are tax consequences, and you may want to look at it at an early stage. The second typical tool and situation would be to work with a subordination. Let's just go back to my example. You have a liability of 100, and for whatever reason, you must do something about it. And of course, you contemplate a waiver, that equity swap and other things. But then, for example, my restructuring colleagues step in and say, well, why don't you just work with a subordination? This would work from an insolvency perspective. And just a comment from a tax side, you should do it correctly, because otherwise the tax law might lead to a full profit in the nominal amount of the liability. There are workarounds, but it should be taken into account. Well, my restructuring colleagues know about this, so I don't have to go into much more detail. But this is also a typical scenario which has serious tax implications. Then the next point, NOLs and tax pitfalls. Let's just go back to the basic idea that restructuring your passive side might trigger profits and thus taxes, just as a starting point. A very good idea would be to make use of tax losses carried forward. Because let's assume you would trigger a profit only for tax purposes, i.e. no liquidity flowing in from such restructuring measures in an amount of 1 million, and you are wondering, do I really have to pay 300,000 taxes on that, money I don't have right now? Well, the answer is no, if and to the extent you can make use of tax losses carried forward. And this typically works, but I mentioned tax pitfalls, and the most important thing you should know is what we call minimum taxation. Germany has enacted a rule which basically says, well, you can use your tax losses carried forward, your NOLs, but only up to 1 million without any limitation, and above that, it's rather limited. So it washes through over the period of time, but again, I'm looking at the liquidity side. So because, for example, generating a profit of 2 million and having 2 million tax losses carried forward would not mean that the sum would be zero from a tax perspective. And the danger here is that you have to pay money to the tax authorities you don't have in this situation. And therefore, you may want to consider some structuring perspectives. The same is also true with respect to share transfers. You should know, and you probably do know, that transferring the majority of shares would or could destroy your NOLs, your tax losses carried forward. And every euro tax loss carried forward has a cash value of around 30 cents. So you may want to consider your structuring options in so far. Of course, it's always good to do it at a very early stage again. Yes, my next point also refers to a typical situation granting new shareholder loans, minimum interest rate. My scenario is that the company needs fresh money and the shareholder is willing to inject money, or even a bank, but a bank would not do it at a 0% interest rate, I guess. But I think we should be cautious about it. Maybe we will see that. But the point here is if a shareholder is willing to inject money at 0% interest rate, the tax law has an old-fashioned rule in light of the interest rates nowadays, which basically says if it's non-interest bearing, you will have to discount it at a rate of 5.5% per year, and this could lead to a substantial profit. For example, if you discount it with 5.5% over a 10-year period, I don't have the numbers at hand, but you may have a taxable profit of 20% of the face value of the loan. So you should always include a reasonable minimum interest rate when doing that. And we have some jurisprudence which says you cannot do it retroactively, and it's very difficult to declare, oh, it was just a mistake, we always wanted to have an interest rate included, etc. So just as a basic information, have a look at it and include, for example, 1 or 1.5%. It probably would hurt less than the tax consequences. Yes, and in addition to all these bad news, some good news. We also have tax relief for restructuring situations. As my insolvency colleagues know, there have been heavy debates over the years over tax decrees, etc. Now we have it in our Income Tax Act with a law which basically says if someone waives a loan and triggers such restructuring profits, they can be tax exempt. As a rule of thumb, they will be tax exempt if all this is done from a valid restructuring perspective. There is a way around that, but this needs some proper planning as well. That's the good news. It works for income taxes, for trade taxes, and for corporate income taxes as well. But you should take a look at it together with your tax advisor before doing it. And one final comment with respect to the new packages we were just hearing about. Yesterday we talked about a 2 billion package for startup companies, and before that we were talking about a much bigger package for small and mid-sized companies. We will have to take a look at it, how it works from a technical perspective. For example, if it's structured as a loan from a tax perspective, you have all the implications I was just referring to. So if something goes wrong, even if the state is now willing to give you a substantial amount, you should take all these things we just heard here into consideration. Because depending on the technique, whether it's equity or debt from a tax perspective, from a tax accounting perspective, there will be tax consequences beyond that. And my recommendation is to think about it already at an early stage in order to avoid any unwanted consequences. But we will have to wait until the structures are finally found, and we'll be happy to comment on that in a following webinar, because I think, and I know that these details are not analyzed at a full scale right now, but from a corporate perspective, you should take a look at it. So due to our time restraints, I would like to, and I have to stop here, although I would love to talk about tax issues much longer. And then I will hand over to my colleagues again. Thank you very much for listening.
Yeah, thank you very much, Bert. Thanks everyone for participating in this webinar. Please stay in touch. We have an overview that you can find in the slides with information on further webinars and also quite detailed information relating to a number of Corona-related legal questions on our website. Please let us know if we shall keep you up to date and keep on sending you respective updates, and please feel free to reach out to us with any questions you may have also after the webinar, of course. Thank you very much for joining and have a great day. Bye-bye.